the previous videos, we talked about the insurance related to the construction project. There are two clauses in PAM contract discussing about the insurance. This include clause 19, mentioning about the insurance against injuries to person and loss and or damage of the property, as well as clause 20 regarding the contractor or risk insurance. In these videos, we're going to proceed with the discussions, making comparison between the two types of insurance as mentioned in clause 19 and clause 20. The comparisons are outlined here. Clause 19 is about the insurance related to the injury to the person and the loss and or damage of the property. This is normally related to the accidents at the work due to the negligence, omissions, default, or the breach of the contract by any parties. The relevant insurance as mentioned in clause 19 include the SOCSO for the local workmen. SOCSO is the Employee Social Security Scheme for the local workmen. It is one of the compulsory schemes for the Malaysian employee. As for the local workmen without SOCSO, clause 19 will require an insurance to cover the losses. There will also be workmen compensation insurance for the foreign workers. That means whoever working on site is supposed to be covered with insurance. In the case that any accident happens, the relevant loss can be covered by the insurance. This insurance is different from the insurance of clause 20. The insurance for clause 20 is the contractor or risk insurance. It is also covering for the injury to person, as well as the loss and or damage of the property. The emphasis are more on the new building or the works, or in the case that there are buildings within the construction site or nearby to the construction site, the employer may choose to also secure an insurance for the existing building. In the case that the contractor would like to insure the construction plans, tools and equipments of the contractor, it may be topped up at the contractor's cost. The number 2 and the number 3 are optional depending on the situations. If you compare two types of insurance here, it seems that this is more people-oriented, usually related to any accidents happen during the work, while in this contractor or risk insurance pay more emphasis on the buildings or the work as specified in the contract. There is a list of the event being covered by the insurance, normally related to the natural disaster, geopolitical threat, and other unforeseen circumstances. If you read between the lines of clause 19 and clause 20, you will find similarity in terms of the requirements. The insurance will need to be in place before the commencement of the work. Both the accident insurance as well as the contractor or risk insurance. There will be joint name between the employer, contractor, subcontractor, and other related parties. The amount insured will be clearly stated in the appendix of the tender document. This appendix is a standard form as given in the PAM Contract 2018. We will have another video to discuss about this in future. The relevant value for the insurance will be stated here. This need to be filled during the tendering process. Also, both insurance will need to be valid up to the completion date plus the defect liability period plus 3 months. As long as there are works to be done by the contractor under the contract, the insurance will need to be valid. This additional 3 months, I believe, is due to the period of the delay, which if you refers to the appendix, by default it is 3 months, in case there are circumstances that may lead to the delay of the work. Now, if there are any delay in terms of the completions or in terms of the making goods of the defects, both of these insurance will need to be extended, and this has to be done at least 1 month before the expiry of the insurance. PAM contract will require the insurance to be placed with the licensed insurance companies, and this needs to be approved or agreed by the employer. This condition here will be applicable for both types of the insurance. We also observe differences between the insurance of Clause 19 and Clause 20. Insurance related to the accidents is clearly stated shall be taken by the contractor. There will be joint names among different parties, and it should be cross liability in nature. We discussed about the concept of cross liability in our previous videos under Clause 19. Basically, any of these parties has the right to claim for the losses against any of these parties under this insurance. As for the contractor all risk insurance, especially when we talk about the insurance for the new buildings or the work, the insurance should be undertaken by the contractor or the employer. Either side will do. Whoever is undertaking the insurance, this normally should have made clear during the tendering process. You see, in PAM contract there are Clause 20A and Clause 20B. Either one will be struck off as appropriate. As for the contractor all risk insurance for existing building or extension, this will have to be undertaken by the employer. Now, in terms of the total insured sum, it will be at least greater than the contract sum plus the sum of the professional fee for reinstatement plus the sum of the debris removal. In conclusions, we have two insurance mentioned in the PAM contract under Clause 19 and Clause 20. The insurance by nature are different, serving different purposes. One is to cover for the accidents happening during the work. Another is to cover for the event that can lead to the damage and loss to the property mainly. Under a construction project, both will be required. The principles of having the insurance in place will be the same, only that who is the persons responsible to undertake the relevant insurance varied slightly, which the employer can choose to have himself to secure the contractor or risk insurance, probably because of the areas to be insured are more relevant to the employer. Although it is the obligations of the contractor, if the employer would like to have better control over the insurance, worried that the contractors are not undertaking this responsibility or obligations, the employer may choose to insure himself.